Welcome, everybody. Thank you for joining the Center for Agricultural Profitability at the University of Nebraska-Lincoln for another in our Thursday webinar series. It happens every Thursday, well, most Thursdays at this time at noon Central. And you can always find a schedule of upcoming webinars and past recordings on our center's website at cap.unl.edu/webinars. My name is Ryan Evans. I'm the communications specialist with the center. And today we are going to be talking about the important topic of succession planning when there's no family heir in the picture. And we're pleased to have presenting with us today Jessica Groskopf, who is an agricultural economist and extension educator based in Scotts Bluff. And through the Center for Ag Profitability and Nebraska Extension, she is in the midst of publishing a multi-part series of articles on this very topic, which I'll drop some links in the chat throughout the webinar so you can read those and have access to them if you haven't seen them already. But today we'll be talking about what happens to the farm or ranch when there is no family coming back to run it, which is obviously a hard question, but one that more and more landowners are facing. Jessica will cover what planning and the right support can do and show that it's possible to create a clear path forward that honors your wishes. And we definitely invite any questions that you have to be typed in through the Q&A, and we will do our best to answer those before our hour is up today. So thanks again for joining us. And Jessica, thanks for being here to present, and I'll let you take it away.
Yeah, thanks, Ryan. So I am so excited to be presenting on this topic. I know here at the Center for Ag Profitability, we talk a lot about succession planning, and time again, we are getting questions about, well, what if there isn't someone in the family to take over the operation? What are our options? Like Ryan said, I really encourage questions in the chat. Not only will I be able to answer some of those today, but also if we need to dig deeper into those questions, we can also use those to write future articles and potentially host future webinars on those specific topics. Today, I'm going to jump into some pretty technical stuff, and I think it's really important that you know that I am not an attorney and I am not an accountant. So this is not legal, tax, or accounting advice. It's for educational purposes only. Today, what I really want to do is kind of get your brain thinking a little bit differently about what will happen to your farm or ranch business. There are some options, but they're not the only options. So I really encourage you, if you are in this situation, that you need your own team of advisors, and I'll talk more about that later, but that would include tax, legal, and accounting advice from that team of advisors. So before we jump too far into today, I want to define some terms that I'm going to use, and I hope to kind of keep things really clear. So today we're going to be talking about owners, and those are typically parents or grandparents who own farm or ranch assets or entities who are looking to pass these assets on to another person. Heirs are typically children or grandchildren who may expect to inherit farm or ranch assets. And in today's context, I'm specifically talking about what I will call off farm or ranch heirs who actually have potentially no interest in actually farming or ranching themselves, but again, may at some point be owners of those assets. And successors is the next term. And here we're talking about the next people or person who is intended to be the next managers of that business. And today we're going to focus on people who are not necessarily related to you. And finally, I'm going to discuss sunset years, which are the final years of a person's life, particularly for owners. Like what does the end of your life in particular look like? So again, just so that we're on the same page, I'm going to try to stick to these terms. So that's owners, heirs, successors, and sunset years. So if you've been following along with the article series, we've been digging through some ideas about farm and ranch succession. And one of the very first articles that we published talked about, what do you want to happen? And whether you have on-farm or ranch heirs or not, this is a question that must be answered. So ideally, what would you like to happen at your death? Now, this is a difficult question. I know it sounds a little bit harsh, but really, we need to get a good, clear picture of what you want to happen when you pass away. Why is that? Because if we build a team of advisors, they're going to be throwing a lot of options at you. And we need to have some sort of a measuring stick to measure those options against. And this question really creates that measuring stick. So let's say that ideally you would like the whatever is left of your estate to be donated to charity. Well, how can we do that, right? And so we're not going to be looking at options that don't ultimately get some of that to that charity. So it's really important that we have this question answered. So if you have never done this before, I highly encourage you, especially if you're watching the recording, it would be great if you could just pause and answer this question. Now, for the rest of us who are viewing this live, who are doing this live, we do have quite a bit of content to go through today. So I'm going to keep moving forward, but I really would encourage you take some time before you talk to anybody about farm estate and succession planning that you answer this question. So this brings us to who is on your team. You are going to need a team of advisors to help guide you through this process. Now, most of us automatically go to the attorney, right? I need the legal, this is how things are going to pass. However, there are other advisors that might be extraordinarily important and have really good input to making sure that whatever you said you want to happen actually happens. So we'll get an attorney, that's one person. Most of us will need a tax professional because there are tax implications of some of the strategies that we're discussing, or all of the strategies that we're discussing. Depending on what's going on and who else is involved, you might need a banker, you might need a financial planner, you might need somebody else, like a life insurance agent, a family facilitator, to help you through this process. Now, no single person can think of every possible outcome, right? No single person can develop an absolutely perfect estate plan. Okay. If we have a team of advisors that we know, we like, and we trust, we will get a better estate plan moving forward. And again, I don't think there's the perfect estate plan. If there was, we could, recommend it to everyone. And we would not be having this discussion today, but unfortunately, that's not the case. Your situation is unique, and you need advisors who know and understand your specific situation to give you the best advice possible. And it helps when those advisors are in the same room and they're challenging one another based on their perspective of how they're viewing your situation. So the other piece that I think farmers and ranchers really get stuck on is that they have heard horror stories of certain tools that did not work, or success stories of tools that did. And what I will say is that your situation is unique, and not every tool in the toolbox is right for you. So you might have heard that, oh, this is the tool that works really well. But there might be, little details of that situation that made that tool the right tool. So I would rely on your team of advisors to provide an idea of what tools are the right tools for you. Today, we're going to be talking about a couple of tools that are available, but they're not the only tools, and they might not be the right tools for you. One thing I can say is that absolutely, basically every adult, but every farmer or rancher needs an estate plan. But not every farm or ranch needs a succession plan. So what do I mean by that? So an estate plan is the process of arranging for the care of a person at the end of their life. It includes the settlement of their debt and the distribution of their assets. Okay, so that basically says, when I die, what is going to happen to my stuff? When I die, what is going to happen to my stuff? And if I need medical care or I need something like that, how is that going to be handled? A transition plan talks about ensuring the continued leadership and management of the business after the key individuals are no longer able to fulfill their roles. So, transition planning, when it comes to farms and ranches, is ensuring that that farm or ranch survives as a business. So, those are two separate things. Okay. For some of you who do not have heirs, you are probably going to be looking mainly at estate planning. However, if you want to start somebody in a farmer or ranch business and you want them to take over your business, then we're going to be talking about transition planning. Okay. So again, it's difficult. There's several people on here, and I don't know your unique situation, but everyone needs to have estate planning documents in place. And if you want to see that farm or that ranch business be carried on by a distant relative, by a tenant, by a neighbor, then we have to start putting into place transition planning tools. Okay. So, what are the documents that are required in an estate plan? And then if we're thinking about transition planning, what types of documents would we be looking at? So again, every adult absolutely needs the first four documents on this slide. So an estate plan, you absolutely need a will, a power of attorney for healthcare, and a healthcare directive or a living will. Those are the four documents. These documents are relatively easy to put together, and they can be updated as long as you are competent anytime prior to your death. I like to think of these as the safety net, right, of a more complicated plan. But the base there are these four documents. So let's go through what these documents do. And again, we have an article that goes through this if you want to read more about it. And Ryan put that link there in the chat so you can go read more about them. So a will assign someone called the personal representative, and what their job is their job is to distribute your assets that pass through the will at your death. That's their job, is to make sure that this goes to this person. That's what a will does. Okay. Now, not all assets will pass through a will depending on how things are set up, but you absolutely need one, even if you have more complex estate planning tools like a trust. Okay. Now, the next three documents, the power of attorney for healthcare, and the living will or healthcare directive, I often like to think of as the documents for your sunset years. But really, they're any time that you cannot make a decision for yourself, if you are incapacitated in some way, these documents will come into play. So a power of attorney assigns an agent, and in the first case, that power of attorney will carry out business on your behalf. Now, this can be very broad or it can be very narrow, but a power of attorney is important to carry on business while you are unable to make those decisions for yourself. A power of attorney for healthcare can only make decisions on your behalf when you are unable to make them for yourself, and only for healthcare decisions. And finally, the living will or healthcare directive is the document that says what kind of care you want. Now, we have a few different people that we've named here. We have a personal representative in the will, we have an agent within our power of attorney for business, and we have an agent in our power of attorney for healthcare. Okay. These can be the same person. They do not have to be. The one thing I will say about that is it's somewhat easier if the personal representative and your business power of attorney are the same, because they are dealing with specifically the business until your death and then can carry on after your death. Okay. However, they do not have to be. I do not like to see multiple people named to these positions. I think you need a primary person, and if you want to name like a backup, that's fine, but I don't want to see panels of people, right? So if you have multiple children, I don't want to see them be co-powers of attorney or co-personal representatives. I think it's important to name one and then have a backup on there. On the estate planning side, today we're not going to get into this, but you may need or want a trust, funeral instructions, and bequests of personal property. If you go back to previous webinars, we've gone more into detail about those documents and what they do, but they are not required for an estate plan. Okay, so on the estate planning side, we absolutely need the first four documents. Let's move over to the business planning side because a lot of farms and ranches have additional business planning documents that should also come into play. So you may have or want or can use an entity like a partnership, an LLC, or a corporation. Um, we're going to specifically talk about 9, 10, and 11 today. So today we're specifically going to talk about lease agreements, option to buy agreements, and preemptive rights that are business documents that will complement your estate plan and help with getting someone else started within the business. So here, I think as I set up today's presentation, I was thinking about how do I make sure that my relatives receive some form of inheritance while getting somebody else started in farming or ranching. Okay, so to illustrate today, I'm gonna show an example family. They're not real. They're absolutely not real. But it's kind of similar to what I see a lot of people coming to me and talking to me about. So here's our family. I have a landowner, and that landowner is a retired farmer or rancher who is already leasing their property to someone. They do have a living spouse, and they also have living children. And that child is not interested in farming or ranching. Okay. Now, since they're already leasing their property, they do have a tenant, right? But this is an unrelated tenant, and that's something I think is important. Now, in this situation, we want to make sure we take care of the spouse and we want to take care of the child, but we also want to pass the business on to the tenant. So how do we do that without completely, negating the role of the spouse and the child? So the goals for this family, just the way that I was thinking about it, was we want to provide a comfortable living for the spouse during their sunset years. If possible, we want to provide an inheritance to that child after the spouse passes. And again, we want to provide the tenant the opportunity to lease or purchase the property. Okay. So again, if you haven't sat down and thought about this, you may be saying, well, this isn't my scenario. I understand that. But I think this is an interesting way to show some of the tools I would like to talk about today. And again, if you have questions, absolutely put them in the chat, and hopefully we'll be able to answer some of those. But if not, we will write articles or do another webinar that address some of those questions that come in today. Okay. So the typical scenario that I see is when I have spouses is they have basically what I would say is identical wills leaving everything to the other spouse, right? So pretty typical is landowner leaves everything to the spouse leaves everything to the landowner, right? So our spouse is taken care of because nothing is sold, distributed, whatever, at the first death. They want to provide that spouse with as much as possible so that they have the means to continue a viable standard of living. Okay. So in our scenario today, unfortunately, the landowner is going to pass away. Okay. So landowner is going to pass away, and the spouse will change their estate plan to now everything goes to the child after the spouse passes away. Okay. So that's the setup. Landowner has passed away, everything will go then to the spouse. And then once the spouse passes away, everything will go to the child. Okay. So, as we think about this family's goals, here's the positives and negatives of this setup. For the spouse, the positives here is that there is what we call the unlimited marital deduction. So, that spouse, when the landowner passes away, the spouse receives all of those assets tax free. They pay zero inheritance tax here in Nebraska. And as long as they are a US citizen, they get that unlimited marital deduction. Depending on how things are set up, they will receive at least a half step up in basis on jointly owned assets, and any assets that are that were not jointly owned, they'll get the 100% step up. The other thing is, this really gives the spouse what they need to live through their sunset years. So they can sell assets if they need to, and they can rent assets out. Now, the reality is this does not guarantee that the spouse has enough to live for the rest of their life. So there is potential that they could run out of assets in their sunset years. The other piece here is they have to know how to be a good manager, and that they might not have the skills necessary to be a landowner. And if they sell assets, they potentially will pay capital gains and depreciation recapture on assets that they sell throughout their sunset years. Okay. For the child, it's a somewhat similar setup here. They receive 100% step up in basis on anything they inherit. They will pay a 1% inheritance tax on anything that they inherited. That's the smallest amount that they will receive, and they can rent or sell assets as well. The negatives here are, though, that the spouse can change their will and basically disinherit the children. They may or may not receive an inheritance depending on how much of that estate the spouse consumes. Again, they might not have the skills or the asset or the skills necessary to be a landowner. And again, we still have capital gains issue depending on when and how assets are sold. The tenant here, in this scenario, there's no positive, right? The tenant gets nothing. They have no opportunity or guarantee of renting or purchasing assets once the landowner has passed. So for from the tenant's perspective, even if the landowner wanted to provide them with the opportunity, this setup alone does not provide them with that opportunity. So how do we create opportunity for the tenant while still providing for the spouse and the child? And here I'm assuming that both the landowner and the spouse have agreed that they want to provide this opportunity to the tenant. So this is a choice that was made as a family, that they want to provide these options. So today we're going to talk about three items that we can use. So that's lease agreements, options to buy, and preemptive rights that can complement the estate planning documents, but are not necessarily typical estate planning items that you would think about. So again, this is where these documents work together, and it's an additional agreement between the landowner and the tenant that would kind of flow through to the spouse and potentially the child, depending on how it's structured. So I'm a very visual person. This is my visual of how this works. So the assets are still going to flow between the landowner, spouse, and child, and there's going to be an agreement either to lease or to purchase these assets, which would then cause certain assets under certain circumstances to be sold or rented to the tenant. Okay, so the bulk of the opportunity or the bulk of the assets would probably still flow through, but we have options here that give the tenant the opportunity without denying opportunity to the spouse and the child. So we're going to start out with lease agreements. And this is a very simple way to provide opportunity to that tenant, that non-related successor. And I will say on lease agreements, often The clauses we're going to talk about exist within the written lease agreement, but the spouse and the child or the heirs of the landowner don't realize they're there. So sometimes it's a surprise that the lease agreement will continue beyond the life of the current landowner. So I encourage you, it's a tool, but you might actually already have this tool in place if you have a written lease agreement, and I'll show you what some of those clauses are here in just a minute. As a part of a quality estate and transition plan, please have your leases in writing. If your lease agreement is not in writing, it's it what happens is we default to Nebraska law. And Nebraska law may not fulfill your wishes. So if you want a lease agreement to live on past your life for someone like a tenant that you would like to help, then we have to have that in writing. Because when we have it in writing, then that lease agreement supersedes Nebraska law. Okay, so have your lease agreement in writing as a part of a good estate and transition plan. So what is the basic things that a lease agreement must include? It has to have the names of the landlord and the tenant. It has to have a legal description of the land to be rented. It has to have the rent amount or the shared percentages, the lease dates, and signatures. Okay, that's the basics. Now, a couple of things when we're talking about estate planning that I think can get confusing is knowing how the property is actually owned may change the name of the landlord. So if you are utilizing a tool like a trust or an LLC, make sure that the correct entity is listed as the landlord. When it comes to the rent amount or share percentages, I don't think this is as common as it used to be. When I first started here in Extension about 10 years ago, occasionally we would see something where the lease agreement would say, we're gonna reference a specific lease rate. So the example here is the lease rate will be the USDA county average rental rate. The problem with this, is that that is not always consistent. So USDA has backed off on reporting lease rates. Maybe the survey that you reference goes away. So we really don't like to see that kind of referencing happening, because what happens if that reference doesn't exist anymore 5, 10 years down the road, or it wasn't reported for a given year. So I don't like to see that in the lease agreement. The other thing is that long-term lease agreements for longer than 1 year must be filed at the county courthouse in order to be valid for more than 1 year. Okay, so that's another thing that we see happening is you say, okay, well, we're gonna sign a longer term lease agreement with a tenant, but you didn't take that extra step, and so it was only actually valid for 1 year. Okay, so make sure that if you are going to use lease agreements, that they are properly drafted. I would encourage you to have an attorney draft them. That way we get it right. Now, here are some things that we can put in the lease agreement to help support the tenant. And again, these are fairly common terms that you will find within a lease agreement. So go back and read your lease agreement and see if they have this. So one of them that I like to include is, or like to see, I don't get to include them, I'm not an attorney, but is the transfer of property. So if the landowner sells the property or transfers it, so again, if we're using other tools, like they transfer it to their trust or they transfer it to their LLC, that the lease will be subject to that transfer. Okay. We like to, I I look for terms like it's binding on heirs. So if I, as the landowner, pass away, it's binding on my heirs so that the lease agreement continues after my death. Um, we also want to protect your heirs as well. So I like to see that there's a clause about amendments and that the amendments must be in writing and signed by both parties. And then I also don't want to see someone stuck with a bad tenant. So there needs to be a termination clause that exists so that both parties know what that termination looks like. If you don't have a written lease agreement, there is a great website. It's aglease101.org. They show example leases. And so where I got those sample clauses is from Ag Lease 101. However, these leases are not necessarily Nebraska specific. I still encourage you to have these leases reviewed by an attorney, but it will give you some ideas. Okay, so if you want to do a little bit of background reading, some things you might want to include, you can go look through that aglease101.org. Really great website. We reference it quite a bit, but do know that there might be additional items that we need to include that are specific to Nebraska. Okay. When it comes to leasing, I think there's some important components here. And one of those components is that your heirs need to have the ability and skills to lease that property. So we need to have adequate funding to maintain the property, and we need to have the skills to manage it. So if you don't see your heirs in that place, we can consider a farm management company, but that's one of those training things that I really encourage you to dig deeper into of what do property taxes cost? How do we deal with irrigation, maintenance, and repairs? How close are they to the property? Are they able to go meet with the tenant? Are they able to go check on crops? What does that look like? And I don't think enough folks take the time to think about, are they really ready to manage this property? The other thing is that I see a lot of farm and ranch families who forget about mom. So, dad has been the farmer, the rancher, and he leaves everything to mom in his will, but he's not training mom on those tools, on the lease agreements, on property management. So I really, really would encourage you to think about, if I'm leaving it to my spouse, am I taking the time at the end of my life and my sunset years to make sure that when I'm gone, they have the skills and ability to manage it? I do want to share with you, if you're having trouble finding a tenant, I would encourage you to check out the Nebraska Land Link program. This is a program where we connect landowners with new and beginning producers, which we call land seekers. It's a great opportunity if you currently don't have a tenant, but you're interested in getting somebody started in farming or ranching, is a great place to find someone who is local to you. We have over 200 land seekers in the system right now, and they are eager to meet you and to learn more about how you can have a good relationship together. The other thing is that if you are interested in getting a new and beginning producer started, Nebraska does offer a tax credit to landowners who rent to new and beginning producers. You can check out the Next Gen program from the Nebraska Department of Agriculture. And so that's a really great opportunity for you not only to get someone started, but also then to receive income tax credit from the state of Nebraska. Okay. So lease agreements are a great opportunity, but let's talk about other tools. And we're only going to get into two more tools today, and hopefully we won't go over on time. But we're going to get into options to buy and preemptive rights. So maybe you're sitting in this situation where, you know, maybe my spouse isn't in a position where they are ready to handle leasing long-term this property. Maybe it would be best if they actually sold it, but I want a little bit more control over who they sell it to. So the first way we can do that is called option to buy. You might also hear them called buy-sell agreements. I think the terms are interchangeable here, but I'm going to call them options to buy. So what does an option to buy do? Again, same kind of structural setup. It's an agreement, but this time we're providing the opportunity to purchase specific assets. So an option to buy grants the holder, the person you name, in this case the tenant, the right to buy, but not the obligation to buy that property. Okay. So it does include a price or a price formula, and basically it forces the sale. Okay. So option to buy agreements force your heirs to sell the property within the terms of the agreement. So what are typical terms here? So typical terms is that we're going to have to name who has the option to buy. So in our example today, the option to buy would be the tenant, okay, the non-related tenant. You need to define exactly what they can buy. Um, if it's property, legal description, okay? Um, and then you need to define the time frame of which they have to decide. So how long do they have to decide if they want to purchase the property, and how long do they have to pay for the property, okay? So that how long do they have to pay could be immediately, like they have to pay for it within, you know, immediately. So the time frame though can be interesting. Is it 6 months of death of the landowner? Is it 30 days? Is it a year? You get to decide that. We're going to define the price at which they can purchase it at. After reading several articles from some great folks, other attorneys, other extension systems, one of the common themes I saw in their recommendations was do not use language like book value or fair value. We do need to define either a solid price or a price formula that's very clear. So usually it is something like the average of two appraisals. And we can also include a discount. So maybe it's the average of two appraisals discounted by X. Now you can do whatever you want. Again, I would recommend you work with an attorney for this agreement and they will have some recommendations. But make sure that language is really clear and we know what that looks like. The other part on price is I've seen folks use tax assessed value. Okay. When will the agreement apply? And then finally, how will the transfer be funded? And usually when it's between unrelated parties, it's a cash buyout. Okay. All right. Let's talk about preemptive rights because I think they're really interesting. So preemptive rights are basically like an option to buy agreement, but they do not force the sale and they do not define the price. So let's walk through those and then we can tackle some questions here. So same setup, right? We're going to have this agreement that allows the tenant to purchase assets under some sort of agreement and some sort of terms, and we get to define that. So in preemptive rights, it provides the holder, in our case, the tenant, the opportunity to buy only when someone decides to sell. So it creates more flexibility in the plan, and it cannot force them to sell. So there are two types of preemptive rights, the first right of offer and first right of refusal. So we're going to talk about first right of offer first. So first right of offer says that it gives the tenant the right to purchase the property if the owner decides to sell. So let's say in this scenario, landowner dies, there's a first right of offer for the tenant, and I am the spouse. I could say, I don't want to deal with it. I am going to give the tenant, they're going to exercise their right here. So I can't go and sell that property on the free market. I have to go to the tenant and let them know that I'm ready to sell. Now there's two different ways we can set this up. Either I can go to them and say, I want this price, or they can come to me and say, this is what I'm willing to pay. Okay. So you can play it either way, but basically it's just the first opportunity. Now, if the tenant can't afford it for whatever reason, then I can sell it on the free market. Okay, so it does not force the sale and it does not define the price. It creates a lot more flexibility, particularly for those heirs, the spouse and the child. Now, this could be really limited. They could have this for a limited amount of time, or they could have it for a long period of time. Again, work with your attorney to define what kind of length you want here. The kind of sister agreement or preemptive right to that is the first right of refusal. Okay, so this gives the tenant the right to match any third party offer before the sale is finalized. gives the holder or the tenant in our scenario the right to match any third party offer before the sale is finalized. So basically what happens is, say landowner has passed away, I'm now the spouse, and I decide to sell the property. I go out and I get an offer from a third party, from someone who is not the tenant. I have to disclose that I have the first right of that there is a first right of refusal agreement. However, before the property sells, the tenant can come and say, I'll match their offer. Okay. Again, it does not force the sale and it does not define the price, but it kind of makes a little bit more of a market. Sometimes the first right of refusal, especially if it goes to auction, will suppress the sale price because bidders know that they might not get it anyway because there is this first right of refusal out there. Okay. So that's first right of refusal and first right of offer. There are scenarios where where the tenant could have both. So depends on how you want to set it up, but basically what happens in this scenario would be the owner decides to sell, then the tenant would put in the first offer. If the owner rejects the offer, then they put it on the free market. They disclose the first right, um, the first right of refusal. They disclose the first right of refusal, but before the property sells, the tenant could match whatever offer they get, third party offer they get. Okay. So you can see this stuff gets complicated quickly. And so again, if you have or want to use any of these tools, we are working with a competent attorney who knows exactly what you want and does a good job of defining them. So I'm going to go through the benefits and drawbacks of the option to buy. That's at the two ones at the top of the screen. For the spouse, the option to buy has defined and can be somewhat flexible terms, right? They are forced to sell if the tenant or the holder has the means to purchase that property. They do have to uphold the agreement, so they will be forced to sell. And the spouse may not like the terms, and they may have to wait a little bit of time if you gave a longer runway in when they had to exercise that option. So they might have to wait for that sale. Okay. For the tenant or the holder, it's the right, but it's not the obligation. They know the terms so they can prepare to fulfill those terms. The reality is it still may be too expensive, especially if there's some sort of price formula that's there. It just might be too expensive for them. And usually there's a pretty limited time to execute these types of agreements. Okay. In terms of the preemptive rights, this gives more power to the owner. It only comes into play if they decide to sell. They have the ultimate decision to accept or reject offers. But the reality is they might want to sell and the market might be down. And then, we have that one that might limit the upside potential. On the tenant side or the holder side, it creates opportunity and they can prepare. But again, it might be too expensive or it might not be the right time, right? So those are both challenges here. Again, I cannot emphasize enough for both of these types of agreements, for the option to buy and the preemptive rights, have a professionally drafted agreement. Review it with the heirs. Make sure that your heirs understands how these agreements should work, right, and how they will work. Make sure the holder knows exactly how to exercise the option to comply with the terms. And if the agreement is for real estate, it should be recorded with the county register of deeds. Okay. Now, all of this can be layered together. So the tenant could have an option to buy shortly after death. They could have preemptive rights once the option expires, and they could have a lease agreement. Okay. So know that these are puzzle pieces that fit together. Okay. Again, these should be drafted by an attorney, and they should be filed appropriately. And these are just a couple of tools, but but they're not the only tools. Okay. So a comprehensive estate and transition plan is probably going to use multiple components. And again, these puzzle pieces have to fit together. So I actually left us quite a bit of time to go through questions. Again, I'd like to remind you, I'm not an attorney and I'm not an accountant. So you may hear me say that you will need to ask those deeper questions to one of those professionals. But we can start out with some Q&A. Ryan, what do you got for me?
Hey, thanks, Jessica. And we would like to remind you, if you do have a question, please type that in the Q&A or in the chat box. And I'll start with this one that just came in as you were talking there. It's just a question: is a lease agreement considered a public record?
So, not necessarily unless it has to be long-term filed at the county courthouse. And then I don't know how that's considered public record or not at that point. So, like a regular lease agreement that's less than 1 year is not a public record.
Great. Okay, so we'll go back through the Q&A now. If the farm is running on a line of credit, will the bank shut off that line of credit? And how quickly can they immediately call in the note for that line is the question.
So remember when we go through the process of closing out your estate that we're going to settle all of that debt at that point. Um, I would have to go back and read what your loan documents say, but I would assume it also has some sort of binding on heirs or binding on estate clause that would be settled within the estate.
Great. Another question was, which office does the lease agreement at the courthouse? Does FSA office also need to have a written, signed, and notarized series of agreements?
I think you'd have to go ask the FSA office. But remember, what we sign at the FSA office is not necessarily a lease agreement. So, where you denote who landlords are, that's not necessarily a written agreement. So, your lease agreement document is separate from what you sign at FSA as a lease agreement.
Thank you. And a question if about giving land to tenants, I guess the option of gifting it to perhaps an unrelated party.
So absolutely, gifting is absolutely possible. I think what's challenging for most farm and ranch families is thinking about if there are living heirs, you are eliminating that as income potential or inheritance potential for those other heirs. I do have an article drafted about gifting, and if you have an estate that is large enough that you feel like you can gift assets to that unrelated party, that's absolutely possible. There are some considerations around that. And so I hope to tackle that in a future. Like I said, I've got a drafted article, but if we need to do some more on gifting, we can surely do another webinar that specifically goes into just straight out gifts.
Great, thank you. And we'll remind people, if you do have a question, please do type that in right now to the Q&A or chat. We've got a few minutes left if we need to hang on here with Jessica. She's happy to do that, and we'll stick on. But that is all the questions we've got for now. Um, as we hang on and wait for others to come in, I'll just mention we'll have up soon information about next week's webinar, which may be of interest to people here. Another colleague of Jessica's, an ag economist for the Southeast region, Anastasia Meyer, will be doing a webinar on issues related to farm inheritance if you are on the end of recently inheriting a farm. So that will be on our website at cap.unl.edu, hopefully by tomorrow afternoon. And you can check that out for registration there. And next question that came in is asking about what a 132 exchange is and how it fits into estate planning.
So again, I'm not a tax accountant. I'm not sure what a 132 exchange is. We might be able to 1031 exchange
Sorry,
land.
1032.
What?
1032, sorry.
I'm not aware of 1032. Aware of 1031s. But again, we can add that to the question list and we'll come back and address those.
Yeah, looks like it's an exchange of stock for property, but
Yeah,
like you
not
said,
familiar with that.
okay.
So
Um,
10 let's pause here. 1031 exchanges are exchanges of like assets for like assets. So like rental property for rental property. So if we're renting farmland, we want to sell it and we can exchange it for something else. There can be some tax advantages of doing that. But again, I'm trying to think of how that plays into this particular scenario. So, I mean, I think there could be a potential, you know, exchange piece there, but I'm just not sure of the full context of the question.
Okay, yeah, thanks. And then they just got back and clarified that they indeed meant section 1031. Um, and then let's see hope you do a session on gifting land to non-family members. So as you said, you've got an article coming out, so hope people stay tuned to the Center for Ag Profitability's website for that. Let's see, can entities like LLCs or sub S corps be good ways to transfer ownerships by shares if there are multiple heirs?
Yes. So again, I think thinking in the context of non-related folks, I think there's absolutely a possibility that we could have a tenant who's either being gifted or who is purchasing shares of an entity, whatever that happens to look like. So yes, we do see that there are more people who are utilizing those as tools, and again, could be a great future topic of how do we actually set that up.
Great. Next one asks if you wanted to gift a part or percentage of the sale of your farm or estate to a community group or the university, what is the process or the order to list those groups to support them tax-free?
Yeah, so again, another draft article that's in the folder is about that specific gifting to charities, and there's multiple ways that you can gift to a charity. What I would say is, I think the most important thing when it comes to that is actually reaching out to those organizations early, because some of them have specific ways that you can gift like tools that you can gift with, and that's not the same across all charities. Of course, you can just make a donation after your estate is settled, but you can also do other things like using a charitable remainder trust that might also be of interest, that again, depending on your situation, provides potential income for heirs now, but at the end of their life then provides a donation to the charity. So we can dig more into those topics. And if you have something, again, whether it's the LLCs and shares or gifting outright or gifting to a charity, email us at cap.unl.edu with your situation, and I'll take those into consideration as I write the next round of articles related to these topics or refine the draft articles that I have put together.
Perfect. Thank you, Jessica. Thanks for the questions so far. These are great. Again, we've got just a few minutes left. If anything comes to mind here, please type that in now. I will let you know if you close out of your Zoom window here, you'll be presented with a very quick evaluation. You can just give us your feedback on today's webinar and any ideas for future sessions. That really helps us inform our work here at the Center for Ag Profitability, and we appreciate that feedback greatly. So we'll also remind you to stay tuned to, again, our website at cap.unl.edu. Jessica is continuing this series of articles on farm succession planning without a family heir in place. So I know that, you could probably run this series forever, Jessica, as new things keep coming up. But a lot of great information is there, and you'll also receive those in your email as you have registered for this webinar. Look for those coming out usually on Tuesdays and Fridays. And I don't see any other questions right now. So Jessica, unless you have anything else, I think we can go ahead and wrap it up. But we certainly do encourage you to get a hold of us if anything comes to mind after this webinar is over, and we'll be happy to do our best to help.
Yeah, sounds great. Thanks, Ryan.
All right. Thank you, Jessica. Thank you, everyone, for attending today, and I hope you have a great afternoon.
Thanks.